Okay, thank you. Ken, anything from you?
No, Judge. Thank you.
Okay. All right, BDC. What's your name, sir?
Chad Moore.
Speak up.
Chad Moore.
Chad Moore.
Yes, sir.
All right. Mr. Moore, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The tickets are P1463343. Driving a registered motor vehicle, no insurance misdemeanor. Ticket P1464667. No insurance misdemeanor. Driving a registered motor vehicle. Ticket P1468849. Failed to display valid operator's license. And ticket P148945. Disregard red amber signal. In each of these misdemeanor matters, sir, you're given a personal bond of dollar amount pre-trial April 10th in front of Judge Wagner. Now to your main matter. This is case number 240-610-0901. Pearson Michigan versus Chad Moore. Appearances, please.
Jennifer Douglas for the people, P72748.
Oh, Ms. Smith, can you bother them again? All right.
Magistrate Burton,
Yes,
can you repeat the traffic court date for me, please?
April 10th.
Thank you, Your Honor.
You're welcome. All right. For the defender's office, I already called Mr. Chad Moore. I'm looking for an
Chad Moore.
appearance from the defense counsel.
We'll bring it on behalf of Chad Moore. Judge waive the reading, stand mute. He's been advised of his rights.
All right, the court will continue not guilty plea on behalf of Mr. Chad Moore. Mr. Moore has a capious bond set February 21st of this year, 10% by Judge Aaliyah Sabri, which is transferred over to Judge Giles. He wants that bond to continue.
Judge, can
10%.
is it in the ROA, Judge? I mean, is it, because I looked for that. I talked to Mr. Moore. He was in court on 1/17/25. He zoomed in, but then he also got a ticket date that day too. They gave him, and it got, everything got messed up and confused. But he was here on the 17th. He says, "What is the file?"
This is February 21st.
No, just can you look back to 1/17 in the file? Because I don't, in the computer, it doesn't talk about the 21st. In the ROA. The ROA is one of the most confusing things I've seen.
Here for a Zoom hearing on January 17th.
It says failed to
Okay, let me
appear.
look back. Okay, all right. He had a Zoom hearing on February 25th. He posted bond on that. He posted $100.
Correct. And he was here on the 17th.
But then he had another failure to appear, I believe.
But he shouldn't have been failed. He was here on the 17th for arraignment.
Mr. Reagan?
Yes, sir. Yes,
You
sir.
can argue all this on bond redetermination on Monday. I'm not going to go back and forth with you on this. Okay?
I'm just asking what the
bond
file says, Judge. What is the file?
Okay,
say?
I have a capious and a bond that I'm going to continue by Judge Giles. So bond redetermination will be Monday, March 17th. Probable cause, March 20th in front of Judge Robbins. Preliminary examination, March 27th in front of Judge Giles. Step aside, Mr. Moore.
Okay,
That's
Judge,
cool.
and I understand that, Judge, but I'm just asking the court what the file said, because I can't see it in the system because the ROA doesn't speak about it. ROA if you type in ROA, it doesn't say anything. It's just most confusing thing I ever saw.
I'm confused, Your
I
Honor.
got failed.
I
Hold on,
was
Mr.
here on the 17th of March. I was here on the 17th of January. I never got a new court date.
Mr. Moore,
Hold on, Mr. Moore.
Mr. Reagan,
Hold on, Mr.
Mr. Moore, Mr. Reagan.
I'm sorry.
I have my instructions
No, I get
and-
that. I get that.
and I have no authority to change the bond. Gentlemen, on Monday, you can argue that your points on Monday in bond redetermination for a person that has authority to change the bond. Even if I heard you from now till 4 o'clock, I couldn't do anything regarding the bond. Step aside, Mr. Moore.
I didn't know. I was in it. I was 13.
But in the-
Right there.
Change Jamal Muhammad.
What's your name?
Change Jamal Muhammad.
Mr. Muhammad?
Bro, this is some bullshit, bro. Niggas got me in this.
What'd you say, sir?
Nah, I was just saying this is some messed up stuff that he got me in, man.
Okay, all right, sit still, stand still, be quiet, and look up at the camera. This case number 250-563-8102. People say Michigan versus Rakeem Muhammad. Appearances, please.
Good afternoon, Your Honor. Good afternoon, Mr. Reagan. Samuel A. Ragnan, P23-157 on behalf of the people.
Philip Reagan on behalf, is this Mr. Muhammad?
Yes.
Waive the formal reading stand mute, Judge. He has been advised of his rights.
All right, the court will not guilty plea on behalf of Mr. Muhammad. Bond recommendation, Mr. Ragnar.
And people are asking for a remand pursuant to MCL 6.106B, parent 6. This is an armed robbery. It also is a carjacking. This incident, the defendant was actively involved in the carjacking, having been picked up by another co-defendant. And then this defendant himself punches the victim in the face. And then he tells the other co-defendant to shoot him, which means evidently there is a gun because the victim was in fear for his life. Your Honor.
Sir, don't say a word. Go ahead, Mr. Ragnar.
And then when they were able to arrest him, eventually he had the key fob to the stolen vehicle in his pocket. They stole this vehicle from a person that they knew. So I'm asking for a remand, Your Honor. Thank you.
Mr. Reagan?
Judge, obviously the charge on his face is very disturbing. You know, Judge, I'm asking, first of all, that my client's file be marked medical, because I think he has some very serious medical conditions going on over there. He's wrapped in a blanket. He has a lot of allergies, has a rod in his leg. I'm asking for some type of reasonable bond, Judge, or nominal bond. I think a remand, you know, he's 20 years old. I'm asking the court for something more reasonable, Judge. Obviously, this is an investigative report that talks about a lot of different scenarios, but obviously this case has to matriculate in court, and he'll have his exam and he'll be able to put his defense on. But right now, I'm asking for something nominal. I think a remand, Judge, is
Yeah, the most important thing
Hold
I
on,
can
hold
mention.
on, Mr. Ragnar. Hold on, Mr. Ragnar. I got some questions for Mr. Reagan.
Yes,
All right,
sir.
sorry.
All right, is he employed, Mr. Reagan?
Judge, he is employed. He works at a plant, and he works at the plant. The name of the plant is called Levante. He works from 5 p.m. to 12 a.m.
All right, how far did he go in school?
Plant is on DeQuinder, 11th grade, Judge.
Okay, Mr. Ragnar, you have the last word. What do you want to say?
Well, I think most importantly in the investigators report, this defendant admitted to being at the scene of the robbery, admitted to hitting the victim. He admitted that he was in the front passenger seat of the car after the robbery. He also admitted that he had the car keys and that he was fleeing from the police. He admits to having the keys in his possession. So, and he knew the car was stolen. Know what more could be.
Mr. Ragnon, I agree with you. I'm going to remand him on the MCR 6.106 in the custody of the Wayne County Jail. I believe there's clear, convincing evidence, at least at this stage, that he has committed this crime. That's going to remand him in the custody of Wayne County Jail during the pendency of this case. Probable cause March 25th, preliminary examination March 31st in front of Judge Taylor. Step aside, please.
Thank you, Young.
And Judge, I just, no, okay.
Step right in the black line, Mike. Face the camera. Say your full name, Mike.
Michael Charles Stitt, sir, Your Honor.
Michael Charles Stitt.
Yes, Your Honor.
It's case number 250-447-2901. Houston, Michigan versus Michael Charles Stitt. Appearances, please.
Jennifer Douglas for the people, P72748.
Philip Reagan, on behalf of Mr. Stitt, Your Honor, waive the written stand mute. He's been advised of his rights.
Court will not guilty plea on behalf of Mr. Stitt. By recommendation from the people.
Your Honor, on Mr. Stitt, the people wouldn't object to a personal bond. However, we would ask for a tether. Mr. Stitt has 2 other cases pending, one of them being 2404527201, date of offense April 8th of 2022. Although it wasn't authorized until October of 24, he was arraigned December 2nd of 24. And
What's the charge on that? What's the charge on that?
that one's a retail fraud third.
Okay. And what's the other one?
The other one is malicious destruction of property, $200 or more, but less than 1,000. And he picked that up while he was capious on the one I just told you about. So he had the one that was a couple years before it was charged, or 2.5 years before it was charged, got arraigned, then picked up the malicious destruction of property case. And then, Your Honor, we do find that concerning. Now, we do recognize that the date of offense here is March 11th to 25. We would note that Mr. Stitt was available to get arraigned on the bench warrants for these 2 cases, pending cases, because he was arrested on the new case, Your Honor. And that's why we're going to go ahead and ask for a tether to help Mr. Stitt comply with the court's orders while his cases are pending and show up to court.
Okay, Mr. Reagan, just please address the issue of tether.
He'll show up to court.
Pending cases.
Yeah, he'll show up to court. I mean, I think he's showing up to court on the other 2 cases that he has. I mean,
he's had multiple failures to appear. He's had multiple.
Well,
I can go through them. Okay.
Does he have a case
So-
tether on those cases?
He does not, but he's picked up a new case.
Oh, okay. Ms. Douglas, let Mr. Reagan finish, please.
I'm sorry.
No, she's fine, Judge. I'm just saying when you say pick up a new case, well, he's alleged to have committed this case, hadn't been proven anything. So we know he has the other 2 cases, right? Or has he been convicted of those? Or those are still pending. So
no, she said they were pending. They're pending. He's not been convicted.
so he doesn't have anything. He doesn't have anything then, Judge. So I mean, we just out here speculating. But I know he's going to come to court. You're going to come to court, Mr. Stitt?
Yes, Your Honor. Yes, sir.
Of course he's going to say yes.
I believe. Well, of course he's going to say it because he's going to come, Judge. So it's a retail fraud, non-assaultive case. So that's the reason why I'm asking for no tether. It's non-assaultive. He has 13 kids.
He's got what?
13 kids. So Mr. Stitt needs to be out working.
Yes.
Mr. Stitt
He's got his most recent conviction, I see, September 14th, out of 43rd District Court.
Yeah, he can't work.
Where does he work?
Yes. Mr. Stitt, talk to him about your employment, Mr. Stitt.
I'm a independent business owner.
What does that mean in English, sir?
I run my own business, man.
What do you do? Do you sell widgets? Do you rap? What do you do?
I
jobs.
I just I do hair.
You know what, Mr. Stitt? I can tell you what I do for a living. It doesn't take me to study or to monitor to tell you. Now, why are you having the same problem?
He does many things, I think, Judge.
Oh, he's a man of many talents?
Many talents, Judge.
Okay, give me one or two of them.
I could play piano even with 4 fingers chopped off. I can still play piano. I've been playing for 13 years.
Do they pay you to pay? Do you have you're a concert tour or something?
I mean, I can be.
You know what? GPS tether, $10,000 personal bond.
Thank you, Judge.
Pre-trial,
You know what?
March 26th, Judge Jones. Stay away from Aladdin liquor.
Okay. I was planning on getting Tether anyway. That way I can stay close to my wife anyway. If I Tether
All
her,
right.
can't kick me out. You know what I'm saying? Thank you, Your Honor.
That's a good
Why?
Never thought about that.
What?
He got to get tethered to the house so he can't get kicked out the house. I never thought about that.
Very funny, Mr. Reagan.
Never
What
thought
up
about
on
that.
Mr. Reagan?
That's what he just said.
Yeah, he's a businessman. He plays the piano. A businessman who plays the piano, right?
Has several times.
All right. What's your name, sir?
Julius Jackson.
Julius
Sir.
Jackson.
Sir.
All right. This is case number 250-563-8001. Pearson, Michigan versus Julius Jackson. Appearances, please.
Steve Benson for the people.
Your Honor, Reagan, on behalf of Mr. Julius Jackson, we waive the formal reading stand. He's been advised of his rights.
Court order not guilty plea on behalf of Mr. Jackson. Given the nature of the offense, ties community, like criminal history, objection to a personal bond, gentlemen.
None from the people.
No, Your Honor, thank you.
$5,000 personal bond, Mr. Jackson. While his case is pending, you're not possessing any handguns, firearms, or other dangerous weapons. Probable cause, March 20th in front of Judge Kevin Robbins. Criminal examination, March 27th in front of Judge Jefferson. Step aside, please.
Place the camera, Henry.
All right, what's your name, sir?
James,
What's your name?
James Henry, Your Honor.
Mr. Henry. This is case number 250-563-8401. Pearson, Michigan versus James Henry. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
We're breaking on behalf of Mr. James Henry, Your Honor. We waive the formal reading stand. He's been advised of his rights.
All right, the court will enter not guilty plea on behalf of Mr. Henry. I received an email from Mr. Vincent, supplemental investigator's report, Mr. Reagan, so you'll know. By recommendation, Mr. Vincent?
I believe I sent it to Mr. Reagan as well. So I hope that he ended up receiving that. We're going to be asking for a 10,000 cash surety. We're going to be asking for a tether curfew as well as an alcohol tether. Just really briefly here. I wanted to send those notes because one, the investigator's report really wasn't all that clear. I wanted to look a little bit deeper into this. One thing that we found in those CAD notes was that apparently alcohol played a part in this incident. The defendant does have a prior OWI in 2013. Secondly, what we found was that the complainant was taken to the hospital as a direct result of allegedly this defendant choking her to unconsciousness, hence the GBH charge. So I wanted to bring that to both of yours attention. I have a defendant right now who has somehow managed to break the law in every decade since 1977. He ended up moving here from Illinois in '88 after he was convicted of multiple offenses in Illinois. And as soon as he gets to Michigan, he's convicted of a CSC third, where he gets 4 to 15. And then in the 90s, he was convicted of a UDAA. And then in the 2000s, he was convicted of that failure to file for the sex register of offenders list. And then in the 2010s, in consecutive years, He was convicted of a DV out of Redford in 11. In 12, he was convicted of that felony larceny from a motor vehicle, resisting, obstructing. 13, an OWI. And then we get to the 2020s, and he has that DVA. Yeah.
I get it. I get it. He's got a, and I see on the notice he's got a long habitual, and habitual fourth offense notice mandatory 25-year sentence. So you're looking for, what was the dollar amount you're seeking, Mr. Vincent?
10,000 cash as surety. I added that alcohol tether only because it appears as though he does have a drinking problem, and now we can see that he's assaulting individuals while he's drinking.
All right, Mr. Reagan, your response?
So, Judge, I understand, he's 63, does have a prior history, Your Honor. And they've been married for 4 years. This I guess allegedly happened at the marital home, Judge.
Wait a minute, how many years have you been married?
And Mr.
Reagan, how many years did you
4
say?
years,
4 or
Judge,
40?
4 years.
4 years. Okay, go ahead.
4. 1, 2, 3, 4.
Okay.
So, and I think Mr.
All right,
Vincent, made a great point. Can you hear me?
You're going in and
Every time I
out.
talk,
You're going in
okay.
and out. You're going in and out.
So I think Mr. Vincent made a great point, Your Honor, about alcohol. I think alcohol probably.
Mr. Reagan, we didn't hear that part. Say that again. We didn't hear that.
I said, let me skip past the part where I said I think Mr. Vincent made a good point, because I think that's what he wanted me to repeat. So, Judge, alcohol played a part in this. I think it did play a part in this from maybe both sides, Judge. I think my client, may have had some issues, but the complainant, my client says she was passed out, drunk. She was drinking. She socked him, and he almost had an accident. She'd been drinking all day, and this is a situation I think, if both parties, Judge, go their separate ways, he's going to go stay with his brother. Now, just understanding that and understanding the dynamics of relationships sometimes,
Okay. Is he employed?
Yes. Judge, he's a auto mechanic. He's employed he's 63 years of age, employed as an auto mechanic. He's also under doctor's care as well, because he does have high blood pressure and he has prostate issues, Judge. Had some cancerous scares, so he's looking at that right now as well about his prostate.
I wouldn't have a problem with what defense counsel is saying, but for the fact that his most recent conviction, which came in February of 2020, was a GBH that was pled down to a felonious assault. And I don't have anything on this gal, but yet I have all of these prior assaultive crimes, the criminal sexual conduct, the domestic violence, the FA, of recent. And now we have an individual who ended up having to go to the hospital because allegedly he choked her out. So I'll leave it with that, but we do feel as though he's a danger.
Mr. Vincent, I agree with you. He's a danger to the complaining witness. I'm going to adopt your recommendation. $10,000 cash surety. No alcohol while this case is pending. You're not possessing handguns, firearms, or other dangerous weapons. No contact with Wanda Hicks. You cannot go back to the Madeline address. Is this an affordable bond for your client, Mr. Reagan?
Unaffordable, Your Honor.
Okay, bond redetermination hearing will be Monday, March 17th, in front of Chief Judge McConaughey. Probable cause March 21st, preliminary examination March 27th. Both in front of Judge Jack Kay. Please step aside, Mr. Henry.
Thank you, Your Honor.
Thank you.
Magistrate Burton,
Yes.
I have a Mr. Hadley who is hard of hearing. He may need a ASL interpreter. I'll find that out. And I have a Mr. Walford, Attorney Reagan, that still needs to be interviewed. Thank you.
Okay, thank you.
Were you able to interview Mr. Hadley? Mr. Reagan?
Judge, give me 1 second. 1 second. I'm sorry.
Say what? Don't step on the black number. Thank you, Judge. Say your full name.
And Terry Benson.
Benson?
Yes, sir.
All right, you have some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside the arrest warrants, your personal bond, and EC's misdemeanor matters that carries a maximum penalty of up to 93 days in jail and/or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney. Can afford attorney. One will be appointed on behalf. The ticket is P1340643. Allowing an unlicensed driver to drive. Ticket P1476325. No insurance, misdemeanor, driver license not valid. And these misdemeanor matters, so you're gonna personal bond or dollar amount pretrial, April 11th in front of Judge Yancey. Now to your main matter. It's case number 250-563-8301. People said Michigan versus Terrion Benson. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Reagan, on behalf of Mr. Benson, waive the reading stand. He's been advised of his rights.
Court not guilty plea on behalf of Mr. Benson. Given the nation offense, not criminal history, ties community. Any objection to a personal bond, gentlemen?
No, I would ask for $5,000 personal bond if that's good for the court.
All right, $5,000 personal bond, Mr. Benson, while this case is pending. You're not to possess any handguns, firearms, or other dangerous weapons. Can you give me the dates on this one? Unless the tab fell off. For Giles.
So March 20th. March 27th.
Okay. Probable cause, March 20th in front of Judge Kevin Robbins. Preliminary examination, March 27th in front of Judge Giles. Step aside, please.
Thank you, Your Honor.
You're welcome.
Separating the black line, face the camera, say your whole name.
Dear Curse, how you doing today?
How you doing, Mr. Curse?
All right.
Yes, I hear you. It's case number 250-563-7901. Houston, Michigan versus De'Aaron Curse. Appearances, please.
Jennifer Douglas for the people, P72748.
Philip Reagan, on behalf of Mr. Curse, waive the reading stand. He's been advised of his rights.
Court will not guilty plea on behalf of Mr. Curse. Final recommendation from the people.
Your Honor, for Mr. Curse, the people are going to ask for a bond of $25,000 cash or surety with tether house arrest work only. Here, Your Honor, we have a very serious offense here with Mr. Curse allegedly breaking into the home of the complaining witness because he believed the complaining witness had stolen his phone. We have officers indicating that they did see damage to the complaining witness's door, that the defendant was found down the street, Your Honor, and then the defendant allegedly told police that he believed the complaining witness stole his phone and that he chased the complaining witness to his home and tried to push the door open, although he claims he didn't make entry. But we have the police saying they saw damage to the door. So, Your Honor, we do have concerns here for safety. I would note that while Mr. Curse does not have anything that would count as a conviction, he did have a 2018 HIDA CCW that he completed, and then a 2019 attempt home invasion first felony firearm under HIDA, Your Honor. And so this isn't his first home invasion first degree case. He was able to complete his HIDA, but Your Honor, that gives us pause and gives us concern that we have somebody saying that now Mr. Curse is forcing his way into their home. This complaining witness said that they had a firearm and pointed it at Mr. Curse, and that's when Mr. Curse ran away. So we have concerns about what could have happened if that complaining witness did not have a firearm. So, Your Honor, we are asking for that bond of $25,000 cash as surety and tether house arrest work only.
Ms. Douglas, how did the parties are neighbors? How do they know each other? Do they know each other?
I don't know how they know each other, but I do believe that they know each other.
Okay, Mr. Reagan?
Yep, Professor.
Mr. Reagan, you gonna unmute and talk to me today?
I couldn't hear anything Ms. Douglas said. She said, how did they know? I couldn't hear anything. It
No,
just
no,
went blank.
she doesn't know how they know each other, if they do know each other.
Oh. Okay, okay. So did you ask me something? I apologize, Judge.
I asked you a lot of things. Want me to start?
Yeah, because it keeps freezing. My camera keeps freezing on you.
Why don't you come in the courtroom, Mr. Reagan, after this
let me
case?
log into. Yeah, and I'm gonna log in on another device, Your Honor.
Okay.
Just
It'd
so
be better
you
if
know.
in person.
Yeah, no, I'm gonna log in.
Okay, Mr. Reagan, go
Yeah.
ahead. Your response.
I got to bear to see Mr. Ragnar. You know? So, Your Honor, I think that, there's a lot to this, and I think it's a lot that's missing. We talk about that my client simply saw a person, came in, ran, said, chased them down, kicked in the door. Like my client said, he never went in the house. There's more to it about the complaining witness having my client's phone. My client doesn't have any type of history of this nature. He's 24 years of age, Judge. He works every day, has a good job, has a 1-year-old child. This is not in his nature to do anything like this. There's more to the story. It's going to get flushed out. I just don't want to, we're not trying it today, so I don't want to get deep into it. But he's not going to be a threat to this individual. He's not going to go near the place. I am asking for the personal bond, Judge, and no contact with the complaining witness as a condition, because there is a existing case right now before you.
I think I must have frozen when I was talking about the 2019 attempt home invasion first and felony firearm HIDA that he had. I don't know if you heard that, Mr. Reagan.
No, I did. And one of the things I want to do too, Judge, is not really ever talk about HIDA cases, because the only reason why they're HIDA is because, they're sealed cases. And the fact that we're on a public forum and everybody can hear this, whether it's employers or anybody else, it's just not. It's the whole purpose of HIDA is, judges, so that it won't be a conviction. And then we talk about it, on a public forum. It's just a little bit. It's kind of uncomfortable, but I do understand I did miss it. But thank you, Miss Douglas. I heard about the gun case. I didn't hear about the home invasion and under HIDA, Judge.
Okay. Court haven't heard argument as to bond. I would inclined to agree with you, Mr. Reagan, that there seems to be more to the story that's not apparent in this report. It's not clear to the court how they know each other, if they know each other. That's one missing piece. And then people just don't go chasing people down the street, alleging a phone stolen just for no reason. There's a lot of background information here, and you're correct, Mr. Reagan. It's going to get flushed out at a later date. So I'm going to give your client the benefit of the doubt. $50,000 personal bond, GPS tether, 9 p.m. to 6 a.m. curfew, no contact with Armonte Cook, no contact with the Burlingame address where this incident allegedly occurred. Probable cause be March 25th, preliminary examination March 31st, both in front of Judge Jefferson. Step aside, sir.
You said days for what again, Judge? I'm sorry.
The days are March 25th, March 31st, both in front of Judge Jefferson.
Thank you, Your Honor.
You're welcome.
What?
Brandon Morrell. Come on, bro. There you go. Just on the big time. Sound that black line? Yes, sir. Face the camera. Say your full name. Brandon Darnell Morrell. Yes, sir.
All right, it's case number 250-563-8202. Houston, Michigan versus Brandon Morrell. Appearances, please.
Thank you, Magistrate. Steve Benson, P70917.
Philip Reagan, on behalf of Mr. Morrell, waive the reading stamp mute. He's been advised of his rights, Judge.
Morrell, I guilty plea on behalf of Mr. Morrell. Bond recommendation, Mr. Vincent.
Magistrate, I know this is a Code D case. I believe this defendant's only, and I don't say that lightly, but he, compared to the other defendant, he's only being charged with the R&O. He's a HAB third too. The other individual is a HAB 4. His most recent conviction was almost 20 years ago. At this time, we're not going to be objecting to a personal bond with any other conditions you feel necessary.
Reagan?
Judge, no objection. I would ask for personal bond on behalf of Mr. Morrell, Judge.
Okay. All right, $10,000 personal bond. Mr. Morrell, while his case is pending. No drugs. Probable cause will be March 21st, preliminarization, March 28th, both in front of Judge Giles. Step aside, please.
Thank you, Your Honor.
Thanks.
You're welcome.
I wonder what's going on with the computer here. It's such a nice computer.
You all right, Mr. Reagan?
Yeah, Judge, I'm just, waiting to get through it.
All right. That makes two of us. What's your name, sir?
Alexis Negron Villanueva.
Does he need the Spanish interpreter?
No, he's fine, Judge. That's Alexis Negron Villanueva.
All right. All right. This is case number 250-563-8701. Pearson, Michigan versus Alexis Negron Villanueva. Pearson, please.
Jennifer Douglas for the people, P72748.
Reagan, on behalf of Mr. Alexis Negron Villanueva, we'd waive the formal reading, stand mute. He's been advised of his rights.
Court on not guilty plea on behalf of Mr. Negron Villanueva. By recommendation, Ms. Douglas.
Your Honor, Mr. Negron Villanueva, the people would not object to a personal bond, but I am asking for tether for the following reasons. Your Honor, we have concerns about Mr. Negron Villanueva showing up. He has a case pending out of 24th District Court in Allen Park for domestic violence. That dates back to 2018. That's case number 18 OS 6062-SM. He was arraigned on that July 22nd of 2018, given a personal bond. He showed up to 2 pretrials and then never showed up again, according to the Register of Actions in that case. He failed to appear October 1st of 2018, and there's been a outstanding warrant in that case ever since. So, Your Honor, we do have some concerns about him showing up in this case. He does have some other cases in other jurisdictions where he has shown up. He has a 2019 assault and battery and purchase.
Douglas,
Yes, Your Honor.
Ms. Douglas, you don't have to recite cases where he showed up.
Okay.
I'm fine. Okay. Mr. Reagan, just respond, address the issue of tether.
Judge, I don't think a tether is necessary. I don't know about the reasoning for the 2018 case. There could be many different reasons. We have no clue about how that case has been matriculating. Judge, I would ask, it's a non-assaulted case. I know you just asked me to talk about tether only, Judge, but I just want to say, Mr. Negron Villanueva was a veteran of the United States Navy, has lived here, Judge, will come to court. I just don't think a tether is necessary in this particular case. So I would ask for a personal bond. Whatever case that is, let them deal with that.
Okay. I agree with you, Mr. Reagan. $10,000 personal bond. While his case is pending, sir, you're not possessing handguns, firearms, other dangerous weapons. I want you to stay away from the mobile gas station on Verner while his case is pending. Probable cause, March 26th, preliminarization, April 1st, both in front of Judge Taylor. Please step aside.
Thank you.
Your Honor, I believe the 2 we have left, Mr. Walford needs to be interviewed, and Mr. Hadley.
Mr. Hadley, they both need to be interviewed?
That's an A from, Your Honor. Mr. Hadley is hard of hearing, Your Honor.
Okay, somebody give me an update, Mr. Reagan.
Judge, are you hard of hearing too? Officer Green.
Yes, I am.
Okay.
Yes, I am. Are we gonna go to the female side or what?
Because we're ready.
I'm sorry?
Let's go to the female side, Your Honor.
Ready.
Okay. And that way, Mr. Reagan, you can do your interviews, or whoever can do the interviews.
Yes. Well, Judge, the problem is we may need a sign language interpreter. We may.
Does your client understand sign language?
We're checking on that now, Your Honor.
Okay.
Which client would that be, Mr. Reagan?
That would be Mr. Hadley. Right, Mr. Hadley.
Okay. Thank you.
Let's figure out what the female side here.
That can definitely be done, but I'm sure that he doesn't necessarily want to stay another day.
Yeah, but,
I'm
okay,
wondering,
well, let's get, hi, DDC.
I'm glad you have knowledge about that implant because unfortunately I do not.
I'm a man of many talents.
I love it. I love it because, you know, that erudition can uplift the masses. You being one of the masses.
All right. Hello, DDC.
How's it going?
I'm fine. What's your name, ma'am?
Starlene Harrison.
All right. This is case number 250-563-8501. Pierce City, Michigan versus Starlene Harrison. Appearances, please.
Jennifer Douglas for the people, P72748.
Good afternoon, Ms. Douglas. Good afternoon to this honorable court. Christina Harris, P52857 on behalf of Starlene Harrison, who stands and waives the formal reading of the complaint and has been advised of all of her statutory and constitutional rights, and she understands those rights.
All right, court order not guilty plea on behalf of the client. Bond recommendation, Ms. Douglas.
Your Honor, Ms. Harrison, the people are asking for a bond of 2,500 cash or surety and no assault of conduct. Your Honor, we have concern here in that this is supposed to have been captured on video of Ms. Harrison chasing this complaining witness who is pregnant with what the complaining witness described as wooden club, but the investigator's report describes as a wooden vase. Your Honor, given that this is allegedly on video, that we have a complaining witness who is upset about what happened. It looks like this is something that's going to go forward and has a high likelihood of conviction. While I don't see any priors, this is concerning behavior between Ms. Harrison and somebody who's a stranger to her. Your Honor, there doesn't seem to have been any provocation here, except that there had been an argument earlier about where the complaining witness parked. And so, Your Honor, we believe that indicates a danger to the public, as this is apparently a building that people can go into if they need to get fingerprinting done. So, Your Honor, that's why we're going to go ahead and ask for a bond of 2,500 cash or surety, ask for no contact, and ask for a condition of no assault of conduct.
Thank you, Ms. Harris.
Yes, thank you, Your Honor. My client, Ms. Harrison, is a life resident of the city of Detroit. She has no criminal record. She actually works at 613 Abbott is the federal defender's office, and she is a security guard at that office. And she says that the complaining witness is a stranger to her. She was abiding by the rules as told that she should, with respect to directing people in the capacity of her job as a security guard. She allegedly had an argument with this complaining witness. She knows the severity of these charges and understands them. She won't have any contact with the complaining witness because she doesn't know who she is or where she is. And she understands that she has to come back for all future court dates, has no criminal record, was gainfully employed. This happened while she was carrying out her job. And for that reason, we're asking for a personal bond.
Okay, Ms. Douglas, got a question for you.
Yes, Your Honor.
You said the complaining witness was pregnant?
Yes, Your Honor. She went to the hospital afterward to get her blood pressure checked because she had concerns because she's pregnant.
All right, do you know why the complaining witness was there?
She was there to get her fingerprints done. She needed to get some fingerprints done, I think, for a job. And so she had an appointment that day, and that's what she's trying to do, is go to her appointment.
Okay. All right, I think this is an isolated incident, and I want to give Ms. Harrison the benefit of that. $10,000 personal bond, no contact with Armand Powell, not a possessing handguns, firearms, or other dangerous weapons. Probable cause, March 26th, preliminary examination, April 1st, in front of Judge Taylor. Like I said, the parties don't know each other. It seems like it may be as little as a misunderstanding. And particularly in light of the fact that it came to the court's attention that she works there, it sounds like an isolated incident, a misunderstanding at best. And so that's why I'm giving a personal bond. Probable cause, March 26th, preliminary examination, April 1st. Step aside, ma'am. What's your name, ma'am? All right, Ms. Beckham, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear warrants for arrest for issue. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days of jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can afford an attorney one will be appointed on behalf. Tickets are P1358094, no insurance misdemeanor. So display valid operator's license. Ticket P1564768, expired. Strike that. No insurance misdemeanor, driver license suspended. Ticket 2805778, allow unlicensed driver to drive. And ticket 468979, no operator's license person. Again, you're getting a personal bond or dollar amount in each of these misdemeanor matters. Pre-trial will be April 11th in front of Judge Yancey. Now to your main matters, calling case number 250-5544601. Please say the Michigan versus Tanisha Beckham. Pierces, please.
Thank you, Magistrate Steve Vincent for the people.
Good afternoon, Mr. Benson. For the record, Christina Harris on behalf of Tanisha Denise Beckham, who stands mute, plays the phone reading of the company, and has been advised of and states she understands her statutory and constitutional rights.
The court will enter not guilty plea on behalf of Ms. Beckham. Bond recommendation, Mr. Vincent.
Magistrate, in full candor, the people are somewhat torn here. The incident occurred in October of last year. We have a warrant that wasn't entered until January of this year, but it's highly assaultive. And we have at least 2 witnesses that saw this defendant use some type of lock as a dangerous weapon and knock this individual in the face to the point where it sent her to the hospital, where she had to receive multiple stitches to this gal's face. As a direct result of this defendant thinking that the complainant, as well as the defendant's significant other and the complainant's boyfriend were having some type of menage a trois between the 3 of them. So because of her misinterpretation of things, she ended up getting physical and she sent somebody to the hospital. And this was just after she had a case dismissed in the 6th District Court last year for, I see it as, charges having to do with guns and reckless use of firearms. The complaining witness in that case failed to appear. And then not even a year later, we have this at a kid's football game, attacking this other individual and sending her to the hospital. So if it wasn't for the fact that this incident hadn't occurred in October of last year, I would be asking for cash. I'm not going to. I will be asking, Your Honor, for a tether, just to keep her whereabouts known, seeing as though this was highly assaultive. And we do feel as though there's a high likelihood of conviction here because the parties all know each other.
Okay. All right, Ms. Harris, please address the issue. Just tether, please.
As to tether, I would say no tether, for the reason that Ms. Beckham is a single mother of 3 children, 8, 6, and 1-year-old. She works on a full-time basis as a laundry attendant, 3 p.m. to 11:30 p.m. And she doesn't work 7 days a week, but her work schedule varies, so she can be working any day, Sunday through Saturday, from 3 p.m. to 11:30 p.m. She is a life resident of the city of Detroit. Now, when it comes to a tether, not necessary. She understands the importance of not having any contact with Ms. Smith, the complaining witness herein. And she stated that since this incident, she has seen Ms. Mills numerous times. Ms. Mills has actually come to her home because the boyfriend of Ms. Beckham and the and the ex-boyfriend of Ms. Mills, they have children together, and the children are brought for parenting time to the house. So I've instructed her, no tether is necessary for the reason that I told her that if Ms. Mills comes to her home for the purpose of dropping off children for her to, if she's sitting out on the porch, or if she to go in the house and have no contact with her. And she has said that she has seen her and been in her presence because of the children in the situation, so she understands.
All right, this is for either Mr. Vincent or Ms. Harris. If either you know, this incident allegedly occurred on the Cathedral address. Who lives there?
That is I think that's a field, an athletic field in the city of Detroit, Your Honor.
Okay,
I
thank
think
you.
that
That's where the football game occurred.
Yes, and that's, if I'm not mistaken, just because of, knowledge of the city of Detroit, a large field near Henry Ford High School is what I believe.
Okay. All right. Court ever heard argument as to bond, $25,000 personal bond. I'm going to give Ms. Beckham a tether. No contact with Shantavia Mills. You're not to possess any handguns, firearms, or other dangerous weapons. I am given the emotion that emotions tend to arise in these cases. I want to make sure Ms. Beckham stays away from the complaining witness in this matter, and that way we can track her with a tether on this in this situation. I understand that there's kind of a quasi-familial relationship here between all the parties, but these parties need to stay away from each other. And I think a tether is the best way to make sure that Ms. Beckham stays away from Ms. Mills at this point in time. Probable cause, March 26th, preliminary examination, April 1st, both in front of Judge Taylor. Please step aside, ma'am.
Thank you.
What's your name?
Demings.
Brianna Demings? State your name, ma'am.
Brianna Demings.
Okay, Ms. Demings, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside this arrest warrants, give you a personal bond. It's misdemeanor matter, carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will use against you, and the right to an attorney. Can afford an attorney, one will be appointed on your behalf. Ticket is P1650152, indecent exposure. Pretrial in this matter will be April 10th in front of Judge Sherman. Now calling your main case. It's case number 240-448-1201. Pearson, Michigan versus Brianna Demings. Appearances, please.
Samuel E. Ragland for the people, Your Honor.
Good afternoon, Mr. Ragland. Christina Harris, P52857, on behalf of Brianna Demings, who stands mute, waits the formal reading of the complaint that is advised of the statutory and constitutional rights, and she states that she understands.
Okay, court will continue and or not guilty plea on behalf of your client. Ms. Harris, I have Ms. Demings Capias, February 27th this year in front of Judge Bryant, who issued a $1,000 10% Capias bond. Why should I not continue that bond?
Well, she stated that she had a doctor's appointment on that date and was not able to come because she had to go.
Was it an emergency?
She said appointment, Your Honor, so maybe she can. Ms.
Demings, was this an emergency or a medical appointment?
It was a medical appointment. It's for my mental health appointment.
You could not get it rescheduled?
No, I couldn't have. It's my schizophrenia.
Okay, go ahead, Ms. Harris.
Did you hear that, Your Honor? She said it's for schizophrenia.
Yeah, I understand.
Okay. And this is an assault and battery matter involving strangers at a tardy store. For that reason, we're asking for a personal bond.
Mr. Ragland?
Well, Your Honor, first of all, she failed to appear also on February 4th, 2025, and then she was arraigned. Well, 123-25, she was given a $10,000 personal bond, but after that, she failed to appear twice. But Your Honor, very assaultive matter with this defendant. I'm sure you've read the report, so I'll try to just go over a few things. She was told she had to leave because she couldn't be in the store. She tried to break the glass. She was escorted out of there by a customer. She comes back in, tries to break the glass, turns over racks of food and different things, those glass jars at the window, at the protective window, tries to get in there. The complainant opened the door to tell her she had to leave, and with
Thank you, Mr. Ragnon. I get it.
Too much.
I get it.
Well, I'm asking that the
I
bond
get it.
remain in place, Your Honor. Thank you.
Okay.
And the tether be added, curfew or.
Okay. I arraigned her previously on, what day was that? January 23rd, and gave her a personal bond. And she failed to appear. I'm going to continue to keep this bond set by Judge Bryant, given her tendency or proclivity to fail to appear in court. I understand she may have some health issues, mental health issues. I get that. But, you know, you got to appear in court or, reschedule a doctor's appointment or whatever. Bond redetermination will be Monday, March 17th, 9 a.m. in front of Chief Judge McConaughey.
Thank you.
Pretrial March 26th in front of Judge Bryant. Step aside, ma'am.
Thank you.
Thank you.
John, continue that $1,000 tip, correct?
Correct.
All right, thank you.
All right, what's your name, sir?
John Walker.
All right, Mr. Walford, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, your personal bond, and each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have right to an attorney. Can afford an attorney one way report on behalf. Tickets are P1270726, no insurance misdemeanor. Ticket P1346261, no insurance misdemeanor. Driver license not valid. Ticket P1350087, driver license not valid. Ticket P1357782, violation of restricted license. Ticket P1470949, no insurance misdemeanor. Driver license suspended. And each of these misdemeanor matters, so you get a personal bond no dollar amount. Pretrial, April 14th in front of Judge King. Now to your main matter. Case number 250-563-8601. Crusade, Michigan versus Dejan Wolford. Appearances, please.
Samuel A. Ragnan for the people. Good afternoon, Mr. Chair.
Christina Harris on behalf of Dejan Walford, who stands me, waives a formal reading of the complaint and understands and has been explained the statutory and constitutional rights.
All right, the court will not guilty plea on behalf of Mr. Walford. Mr. Ragnan, you don't have to go into the detail of the case, the facts of the case. Okay. I did the probable cause hearing earlier today with the court officer in this matter, so I'm intimately familiar. And I asked her a couple of questions regarding this situation at that probable cause hearing. So I just need your bond recommendation, Mr.
We're going to ask
Ragnan.
a $35,000 personal bond. We're going to ask a tether with a curfew if he's working. No more exchanging of children or anything with the complaining witness. And the Detroit Police Department, keeping their domestic violence history on this person, has over 10 assaultive cases where they were called regarding this previous complainant, Your Honor. So I'm asking for the personal bond with the tether. Thank you.
Okay. Ms. Harris, please just address the issue of whether or not I should give your client a tether.
Okay, there was something that was said that is of concern, and he said that no exchange of children. I don't know if court of higher jurisdiction has entered an order regarding parenting time.
I'm not concerned about that, Ms. Harris. I'm just concerned about tether.
Okay, then. So my client understands the importance of not having any contact with a complaining witness. He also understands the importance of returning to court for every court hearing date. He's in community college now. He does not live with a complaining witness and does not have to have any contact.
Mr. Walford, is there a court order indicating a child custody?
Not that I know of.
Okay, if you don't know of it, then it doesn't exist. But from now on, sir, you're not to have any contact with Nicole Sanders. So if there's any child custody exchange, it's got to be done through your mother or other relative with that. You cannot have any contact with her. Is that clear?
Okay.
Not okay. Is that clear?
Yes, sir.
And you're in school, is that correct?
Yes.
What are you studying?
Criminal justice.
How ironic. When do you go to school? What are your school hours?
Between 11 and 3.
Do you work?
Not at the moment, I just been going to school.
Just been going to school?
Yeah.
How many children do you have in common with the complaint?
One.
How old is the child?
4.
Okay, Mr. Radner, you said he has extensive assaultive allegations, you said?
Yes, police reports where they give it a case number to being called for assault, assault and battery, domestic violence, a number of those things. And he also had a CCW 1216, I'm sorry, 121621 was, I thought, dismissed for height, but it doesn't look like it was completed. I don't know.
Okay, I'm going to give you a $35,000 personal bond. I'm going to give you a GPS tether with a 9 p.m. to 6 a.m. curfew, allow you to continue to go to school. No contact with the court. You're not to possess any handguns, firearms, or other dangerous weapons while this case is pending. Probable cause, March 20th. No examination, March 27th. Both in front of Judge Jack Hayes. Step aside, please.
Thank you, Your Honor.
They can do it, but she got another model, can the sign language interpreter, can we do it now?
So what now?
The sign language interpreter?
Yeah.
She can do it, but she need to do it like right now.
Okay, tell her log on.
Magistrate Burton, Attorney Reagan is talking to Mr. Hadley.
Does he need an American Sign Language interpreter? No, that's for Officer Green.
Yes, sir, you do. You need one.
Okay. We're gonna get one to log on momentarily.
Thank you.
Why didn't he let us know this earlier?
Okay, I'll tell my supervisor. Magistrate Burton, I believe Mr. Reagan is talking to Mr. Hadley at this time, and I believe he may need an ASL interpreter.
Well, one is logging in shortly. Any particular reason the court didn't know about this till just now?
When I went and got him, I just found out that there was a hearing sign on his door. Then he acted like he couldn't understand me, so I put him there with the attorney.
All right, thank you.
Yes, sir.
Okay, ladies and gentlemen, I've got the American Sign Language interpreter in there. Good afternoon, Rebecca Hands. How are you?
Well, it's nice to see you again.
Hi,
Sorry,
you all right?
sorry, we're always seen under these circumstances.
I know. DDC?
Magistrate Burke.
I have the American Sign Language interpreter. Can we do what we need to do?
Yes, sir. I'm gonna dial in from DDC camera 2. Stand by, Your Honor.
All right. And Ms. Hines, while I have you here, please raise your right hand. Do you swear or affirm that you translate to the best of your ability from American Sign Language to English and English to American Sign Language to the best of your ability?
Yes, sir.
All right, thank you.
You're welcome.
Are you one of the few people that raise your right hand physically and on Zoom? I like that.
Yeah.
I like that. That's like wearing a belt and suspenders.
Yes.
Okay, where's Mr. Reagan? Ms. Hines, does he understand sign language?
I'm trying to get him to see me. Hello. You want a lawyer? Do you fingerspell only? Can you lip read? Can you lip read? Do you fingerspell? Do you understand writing? Okay, so Your Honor, he is deaf. He does not use American Sign Language. He understands lip reading very little. He fingerspells and or writes back and forth, and he's asking for a lawyer. I told judge need lawyer.
Has he spoken to an attorney today?
You talk to lawyer already? No, the police put handcuffs on me, and I don't. The police, there's no communication, I'm guessing is what he's trying to say. The police took my
Ms. Smith, can I get Mr. Reagan in here, please?
and my they took my belts, they took my things. Yep. Yes. My paper. They took my paper and my pen, and I need that. you need. I know. I told the judge, finish, told. You have to hold. He has not consulted with an attorney yet, Your Honor.
I'm in the room right now, Judge. If they log back in.
Log in. I'm gonna put you in the breakout room.
Yeah, right now.
Mhm. Yeah, it's because you're in jail. Yeah.
Okay, I'm gonna put everybody in a breakout room. Accept the invitation, please.
Yes, sir.
All right, DDC camera 2, accept the invitation to go join the breakout room.
Gotcha.
Okay.
Okay, DDC, first of all, when is Mr. Hatley time out?
Give me a moment to go check his time, Your Honor. 1 second.
Okay, while we're waiting on that, Ms. Hens, Mr. Reagan, and who are the prosecutors on this case? Is it Mr. Vincent, Ms. Douglas, and Mr. Ragnon? Okay, is you Mr. Ragnon?
Yes. It is.
Okay. Here's the issue we have, and Mr. Reagan and Ms. Hens, please correct me if I'm wrong. It's my understanding that Mr. Hatley is deaf. He knows very little American Sign Language. And does he have a cochlear implant? Can he hear at all?
Do you have a cochlear implant? Yes, can you hear a little bit? Can you hear a little bit? You hear a little bit? No, the police, they took my stuff.
No, I don't care.
Can
he hear?
Okay. No, hold on a second, Your Honor. So how a cochlear implant works is there's another device similar to a hearing aid that attaches to the head. If he doesn't have that device, he can't hear.
Ah, okay. And so the police have that device. Okay.
I know.
All right.
24 hours, Your Honor.
I know. I'm helping you.
Okay.
I know. I'm trying to help you.
Let him go,
Calm down.
Judge.
Calm down. I'm helping you.
Okay. All right.
They gotta let him go.
I'm trying to help you. I know. I'm trying to
Mr.
help you.
Ragnon?
Calm down.
Yes. Yeah.
In light of these unusual circumstances,
Hold on.
and given his disability, I want to ask you first, is there any objection to a personal bond so I can release this man and he can be notified of his court dates?
Okay, well, my thought process on this whole thing was that just releasing him will put him in the same situation he was before he got here when he threatened his caregiver. But tethering him to a relative's home where someone could watch over him and take him that he may know and be comfortable with, maybe that would be the best solution. But the personal bond was what I agree with as well. But I think tethering him, I mean, maybe they could eventually find a place that someone who cares for people with dementia and so on that could help him, because it's got to be a terrible situation.
Is that his house, the Farmbrook address?
I believe so.
Judge, he is the complaining witness is his caregiver. And even the report says the complaining witness not willing to make a statement or go to court. So if this complaining witness is not willing to go to court and make a statement, then what's really gonna happen here?
Okay, hold on. Okay. Now, does anybody know, has the firearm been removed from the home?
Yes, firearm has been removed from the home, Your Honor. It was registered to him. It was a shotgun.
Okay. I'm going to call the case 250-563-7801. Case of Michigan versus Roosevelt Hatley.
Samuel A. Ragnan for the people.
And Judge Philip Reagan on behalf of Mr. Hatley, Judge. We got him. We got him back. I think the screen froze, Judge. Over there.
No,
not on me. I heard you.
Not on us.
I heard you.
And I thought that the Miss Hands and the camera DDC was frozen. And maybe that's just mine.
No. We're good.
Okay. Judge,
I need to put myself on the record. Rebecca Hensley, sign language interpreter.
Yeah. Okay. Thank you.
Yep.
And I previously swore you in, Ms. Hines. Okay.
Yes, you did.
Mr. Reagan, do you wait for a reading stand mute?
Judge, this is my only issue. I want Mr. Hatley to understand what he's being shown. If we had a piece of paper over there that could just tell him and he could read it, I would be good with
I
it. If
know.
the person inclined to give him a personal bond, I don't want to just waive, because at some point he needs to understand what's happening.
Okay, Mr. Reagan, let me read him the complaint.
Well, Judge, I can do
And see
that,
if he can,
but he can't hear it. That's the problem.
well, we got the sign language interpreter, you understand someone, let's see if he understands that.
He's not understanding hardly anything. He just keeps telling me, I'm so confused. I don't know what's going on. I have
Right.
dementia.
Okay.
I can't,
All right.
the
This is
cops
what
took
we're
my
gonna
stuff.
have to do.
Yeah.
AJ,
All right,
give
we're
the report to
gonna,
read.
just listen. DDC, we're gonna have to have Mr. Hadley come in person tomorrow.
Tomorrow. You have to come
Okay.
tomorrow.
All right, so bring him in person tomorrow, and at the very, very least, he can communicate with his attorney in writing.
Okay.
And can you have him with the stuff he needs or the materials he needs for the cochlear implant so he can hear? Can you have that brought along with him? I believe it should be in his belongings.
Yes, Your Honor.
Okay,
They're gonna let you
we're gonna
go
adjourn this
home.
matter to tomorrow morning.
You have to come
Your Honor,
tomorrow. Have to
Can I
come
just
to
ask a
tomorrow.
question, please? Is there,
Yes,
I mean, not knowing if there is a relative involved that could help, not knowing if the caregiver is going to wants to go back and take care of him, but someone needs to take care of this man. I'm not looking to put him in jail. I'm not looking for him to have problems. I'm just looking for him to try to find some help with someone. So I don't know if there's a
Correct.
change, someone can talk to the caregiver, or the interpreter can find out if he has a relative they can call.
no, that's Mr. Reagan's situation now. The issue that, hold on. The issue that the court's facing right now is for Mr. Hadley to understand what's going on. And it's clear to this court, he is not able to communicate with Ms. Hens, the American Sign Language interpreter, and his attorney. So there's been a breakdown in communication at a fundamental level. So I want to adjourn this till tomorrow morning. He can come in person. And at the very, very least, if these issues still continue, he can write, which he can do, and communicate with his attorney face-to-face in writing, and we can have an understanding. And those questions you asked, Mr. Ragnon, does he have another place to stay and so on and so forth, can be communicated properly at the very, very least in writing with his defense attorney. He's not timing out anytime soon. And I think that's the best interest of justice because he clearly does not understand what's going on here.
Yes, that sounds good, Your Honor. Okay, thank you, Your Honor.
Thank you, Your Honor.
All right.
Madam
All right,
Interpreter.
we're gonna adjourn him to 10:30 tomorrow morning in person. That's clear, DDC. You're gonna bring him in.
Yes, Your Honor.
Okay. All right, everybody have a good day.
All right, have a good one.
Do you want to have a breakout room to try to explain to him that he's got to spend the night, or? But I'm just making a suggestion, Mr. Reagan.
All right, magistrate, talk to you later.
Okay.
See ya.
Yeah.
All right, good job,
I
Mr.
just wanna say
Ragnon. Thank you for the
we
suggestion.
had already discussed that was a possibility, Mr. Ragnar.
All right. Have a
Okay.
good evening.
All right, thank you.